Hello and welcome back, your lovely faces, to another video here on the channel. Well, ladies and gentlemen, we have an update from Twitter and how they're actually planning to move ahead with this whole I want all these bots accounts. And let's just say, ooh, it's so funny. They've gone from over 200 accounts and now it's just whittled down to 2. So as you can see from here, ladies and gentlemen, it is coming from the real Laura Bokov. If you're not following her on Twitter, this is her Twitter address. Go and follow her, guys. She is absolutely amazing. And this is what she says. Update. Johnny Depp VAHCA. Twitter status update status that they have narrowed it down to the most offending Twitter accounts, which is 2. That's just amazing. Twitter have gone through it and they're like, yeah, we've only found 2 accounts that are offending. And I just think that's really funny. And that they still oppose providing the information unless court compels. I can't see the court compelling it because it's just 2 accounts. But this is what we got, obviously, in the images. So, Superior Court of the State of California, County of LA, going through them all. Nature of the dispute and background. Defendant AH issued a subpoena to non-party Twitter in connection with litigation against Johnny Depp in the Circuit Court of Fairfax County, Virginia. The subpoena seeks, in relevant part, IP address information for over 200 Twitter accounts, which, to be honest with that, is very dangerous because someone like AH having that type of information, we don't know who should give that information to. It could be like, oh yeah, these are not for people to know. But she'll be like, oh yeah, here we are, guys, these are all IP addresses. Do you know anyone who can fix this? Exactly like she said about the vet who she tried getting to fake the documents for her dogs to go to Australia. Anyone we can squeeze, anyone we can give any money to. So if she's willing to do that for her dogs to get into a different country, she would definitely give these addresses to people so people can get doxxed and harassed online. So it goes here, the defendant alleges of bot accounts. Yeah, that supposedly published smears and misleading statements about her and were maliciously operated by or at the direction of Johnny Depp. During a January 28, 2021 informal discovery conference, defendant's counsel stated that he would narrow the subpoena to seek IP address information only for the 2 Twitter accounts that counsel claimed were the worst offenders. The court agreed, but required defendant to submit evidence of defamatory statements posted on Twitter by these 2 accounts. That is amazing. But again, that can also be very dangerous because anyone can go into either on the laptop or a PC. All they got to do is press F12, so all the index and all the numbers come up on the side, and you can literally change the text to whatever you want. Then you can copy and paste and then say, oh look, this is what they said. Because again, that is very easy to do. I know that for a fact. Because I used to do it to mess around with my mates and work. And we were like, oh, this person doesn't like you, look at this. But then, if you go and do that, and you actually go out and post it online, like people have against Chris Pratt and everything else, they were like, oh, this guy said this, look at this. And it comes out the metadata was actually wrong. And they're like, oh, yeah, we made it up. It's that sort of dynamic. The court also disagreed with the defendant's representation that the subpoena does not seek identifying information, because IP addresses can be used to unmask anonymous speakers. Defendant's supplementary status report does not appear to identify sufficient evidence of defamation, and from Twitter's perspective, if defendant intends to pursue the subpoena further, she must obtain a court order confirming that her request satisfies the First Amendment. That is so good. I'm telling you, the Virginia court, they are not taking any shit on this case, and I'm glad. Governing law. To unmask an anonymous online speaker, the First Amendment to the US Constitution and the California Constitution require litigants to establish a prima facie cause of action and to attempt to notify the speaker. Moreover, the California constitutional right to privacy requires a showing that there is a compelling need for the discovery that outweighs the privacy rights of the speaker. So now we got to the discussion. It is unclear to Twitter whether defendant's new evidence establishes a prima facie, again, I do apologise guys, these kind of words are not my forte, cause of action. Several of the quoted statements appear to be neutral statements or opinion, which people don't like you have in this day and age. They include language such as, "I'm so proud of Depp fans." Oh my god, that is so heartbreaking and that is so damaging. "I'm so proud of Depp fans." Or refer to defendant, a movie star, as a nobody. Oh my god, they said I'm a nobody. Well, and this is what she's arguing over. Oh my god. Jesus, oh my god. Defendant supplementary informal discovery conference status report at 1-2. Even tweets that appear ambiguous may be statements of opinion, given the nature of the underlying litigation. Fucking hell, I still can't get over that, sorry guys. They call me a nobody. That is not defamatory, oh my god. A newsworthy and hotly debated by fans of the parties, as plaintiffs and defendants counsel attested to the previous IDC, and the party's celebrity status. More, almost all of the identified statements are retweets, i.e. dissemination of another account's tweets, and the act of retweeting could be expressing an opinion about the retweeted statements. Additionally, some or all of the statements could be true. Accordingly, Twitter is concerned that defendants' evidence is anonymous speech that has protected opinion about two public figures. Given these issues, Twitter's position is that a court must undertake the applicable balancing test before Twitter can produce the requested data. And it goes on to say about the IP address information defendants seek can be used to unmask these people, which is very true. Additional issues with defendant's supplementary statement. Twitter is also concerned about two additional aspects of the defendant's supplemental statement. First, the statement still appears to raise arguments related to defendant's harassment claims, even though the Circuit Court of Fairfax County, Virginia, denied defendant's claims in January, as the parties discussed at the January 28th IDC. These accounts republish the content of other users at rates and consistency that belie authentic human control. Again, they have no idea how people work, But we are talking about AH and her little law team, who are literally trying to tell these people in this court, "Oh, you don't know anything about this, yeah? People can't do that." Again, all you need to do if you want to retweet or refresh a page, click. 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 That's all you gotta do. Press a button. That is it. So yeah, continuing to pursue the subpoena, given the parties' discussion on the January 28th, subpoena is moot as the defendant claims it is unclear to Twitter why defendant has raised the issue again in her statement. Second, defendant's statement appears to ignore the counsel's January 28th narrowing of the subpoena of the two worst offenders. The statement cites tweets from several different accounts, not just two, and discusses characteristics of many accounts. These representations and arguments overlook defendant's counsel's commitment to narrowing the subpoena during the January 28th IDC. Proposed solution. Twitter respectfully proposes that if the defendant intends to pursue the subpoena further, she must limit her request to 2 accounts. That's so good. Consistent with her counsel agreement to do so at the January 20th IDC, and seek a determination from the court regarding whether those accounts may be unmasked. Not her claim remains. In addition, Twitter seeks confirmation that the Adam Waldman subpoena has been withdrawn. Wow, ladies and gentlemen, this is just so good because this literally shows that even Twitter are like, yeah, we've had enough of playing your games because you are just so stupid at doing this. And I think that is absolutely amazing. And one of the funniest things as well, even Twitter are like, yeah, we're not going to do that because, again, we got more money than you and we can fight this all day long. And again, we've seen what AH's supposed net worth is, which is $8 million. She still owes $7 million to charities. And if she got, $1 million left over or whatever, that could be her home. She may not have any money in the bank or whatever. But then again, no, Twitter, a multi-billion-dollar corporation, they can fight this till the end of days. They can't against her because she's be the one who's like, oh yeah, I can't afford it, we're going to have to stop. It's that sort of thing, and I just find that really, really funny. Before we end it up, Tug actually said something on Twitter regarding this, what Laura put down, and it was, that'll be Grindelwald and IFOD. They're targeted specifically, which they are. The offer stands, they roll on them, and we'll make sure they have representation if they can't afford it. 100%. Like, if this does happen and these two do go, all of us will just get together and we'll help them all out. Because, again, they do not deserve to be brought into this just because of what they said on Twitter, because of their opinion. When someone takes you to court over your opinion, that just goes to show what kind of world we're living in. If you are new to the channel, please like and subscribe, hit that notification bell for future updates, and I'll see each and every one of you soon.